set this case for the next available jury trial setting. So that one was already granted. The second one is going to be what's called the defendant's pretrial and trial requests and demands. It's broken up into 3 parts. The first part is a written request for a speedy and public jury trial. The second request is pursuant to Article 39.14 of the Texas Code of Criminal Procedure. We are asking that all discovery be tendered to the counsel to prepare for trial. And under the third section, Chapter 25 of the Texas Code of Criminal Procedure, the clerk shall deliver a copy of the information when requested, and we requested it. Just so the court knows, there was a misunderstanding between Susanna and I on which motion the court had granted, and Susanna has already gone ahead and emailed me a copy of the information.
You said that was the first part of 39.14 or a subheading, or what are we talking about?
No, the first one, request number A, demand for a speedy and public trial. Right. We're just demanding our right to a speedy trial.
Right. I understand.
Second one, under request
39.14.
Correct. Just a written request for discovery. Usually, back when we were going into court on regular dockets, I would do this request verbally with the prosecutors and watch them note on their file that I put in a request for the discovery. So that way, if there were any discovery issues that came up later, I would be able to argue that to the court.
When you say that, you're talking about 39.14 or a more broad discovery motion?
No, Your Honor, under 39.14, it says that there needs to be a request from the defense counsel. Since I cannot go into court and request this directly to the prosecutor, I did it in a written motion. So that way, if there's any problems that come up later, I can be able to cite back to this motion.
All right. And you have a third one, I think you said?
Yes, under Chapter 25 of the Texas Code of Criminal Procedure, 25.04 states that when an accused in a criminal case is on bond, the clerk shall deliver a copy of the information.
And you say that's already done?
And that was actually, Your Honor, yes, that was an accident between Susanna and I. I thought you had already granted this motion, and so she emailed me a copy of the information already.
All right. So anything else, Maria?
Nothing further.
You're not going to have a hearing on a speedy trial?
Not yet, Your Honor. I had to put in this request first, so that way after 8 months, I can put in a request for violation of speedy trial.
Very good. All right. Then, Mr. Edelman?
Well, Your Honor, the first 2 subsections, A and B, I think should be, I'm not even sure that they should be denied, but I also don't think that they should be granted, because in terms of the defendant's assertion of a right to speedy trial, it doesn't present a decision for the court to make that the court is actually capable of ordering. And to clarify that, I would ask a series of questions. Let's say that the court grants the defendant's assertion for a speedy and public jury trial and sets this for a jury trial at the earliest available setting date. How does the court intend to provide a jury panel? How does the court intend to ensure social distancing for a jury that is seated in order to ensure the safety of all of the participants? Does the court even have the authority to order a jury panel at this time? And if it doesn't, when will it have that authority? Since these questions don't really have any answers, it seems that the court is not in a position to either grant or deny an assertion of a right of speedy trial. However, it should be noted on the record that the defendant has made that assertion in a timely fashion, and that's definitely to their credit. As far as subsection B goes, the request for discovery under 39.14 is a request rather than a motion, specifically because it does not invoke the authority of the court for its demand for compliance. The request merely needs to be transmitted to the state. As I read 39.14, the method of transmission is not specified, and so it can be accomplished in any fashion that the defendant deems appropriate, including orally. But I think a filed request with a notification to the state should serve to accomplish the goal of timely asserting a 39.14 request and making the state aware of such. And so because 39.14 does not engage the authority of the court, it doesn't seem to me that the court actually has the authority to either grant or deny that as well. And finally, as far as subsection C is concerned, since the court has already provided a copy of the information, it seems that that is granted pro forma. So that is the entirety of my remarks, Your Honor.
Thank you. Anything else? All right. Ms. Gonzalez and Mr. Miller, for the record, the court notes that you have made a request. You have entered a waiver of arraignment, which has been already addressed. You have pled not guilty. The pretrial request for a speedy, open public jury trial is noted within the constraints of the administration of the court itself. We will provide you a speedy trial. Obviously, you have to be aware that under the exigent circumstances that exist, that may be a little bit problematic and maybe have to address it later. On 39.14, the court notes your request for the record, and the state has been fully apprised, and there's nothing there to be done. And the third item, which is Chapter 25 compliance, that, as you had noted, Ms. Gonzalez, has been complied with. So that takes care of Mr. Miller for today. Anything else, Ms. Gonzalez?
Nothing further, Your Honor.
All right. And Mr. Edelman announced that he had nothing further to say, nor do I. Then we'll go ahead and close this matter for today. Kayleen, thank you for your time. Mr. Edelman, Ms. Gonzalez, Mr. Miller, Patty, Sherrera. This thing says Sherrera. I get a kick out of that. Susana Herrera. Y'all have a good day. Y'all
Thank
need
you, sir.
anything? I'm here all day, so.
Thank you, Your Honor. May I be excused?
Yes, you may. Thank you.
Frederico, I'll give you a call after we disconnect. Thank you.
May I also be excused, Your Honor?
Yes, sir, Mr. Edelman.
Appreciate it, sir. Be safe.
Take good care. Michelle?
Judge.
Ma'am.
Okay, Judge. Have a good day.
All righty.
Okay, have a good day, Judge. All right,
Mr.
I haven't
Mr.
gotten any
Miller?
motion.
Mr. Miller, in case you don't understand, you are allowed to leave the meeting now. Close your computer.